Party, the Independent National Electoral Commission, and the President-elect Bola Tinubu, his deputy Kashim Shettima, and the ruling APC were the first to fault respondents.
Now, the Labour Party listed grounds invalidating the candidacy of the APC, as well as corruption or non-compliance with the provisions of the Electoral Act 2022, and indicating that the President-elect was not duly elected by majority of the lawful votes cast at the election. The leadership of the Labour Party and its presidential candidate, Peter Obi, have been given a window period of 21 days for the Elections Petition Tribunal to fix a date for the hearing of his case. And now joining us for this conversation, we have Festus Oguns, who's a human rights lawyer. He joins us from Lagos, Nigeria. We also have Fidel Albert, also a legal practitioner, who's joining us from Lagos, Nigeria. Gentlemen, welcome to the conversation. All right, Barrister Albert.
Thank you very much.
Wonderful. Now, Barrister Albert, let's begin with the first ground brought before the notice of the tribunal, that the presidential and vice presidential candidates of the APC were not qualified to contest for the election. Now, according to the petition, the presidential candidate at the time of the election was fined $460,000 by the United States for drug trafficking, while the vice presidential candidate was already nominated for the post of Borno Central Senatorial candidate while fielding the vice presidential post. Now, Barrister Albert, with these indications, how does this invalidate, or how could this potentially invalidate the candidacy of the APC?
Election petitions, for the petitioner, I would say that it's a very long road. The journey is still very far. I like the word that you used, or the adjective that you used to qualify the issue of invalidation. It's potential, because while it may be grounds, all the allegations that have been made are left to be proven. So petition is one thing, but there is an opportunity for the respondents to the petition to also state their own side of the case. So right now, we've only seen or heard of the petition that has been filed by the Labour Party. And by the way, as of today, I'm aware that PDP has also filed their own petition. And I think the AAC or one of those other parties have also filed. I've seen 3 petitions that have been filed, but it's still a very, very long way to go. On the issue of the conviction, that issue has of Tinubu in the United States, that issue has been long in the news. We've all heard about it. But we must remember that the Constitution limits, first of all, says there has to be a conviction of a criminal offense. Whether a forfeiture proceedings amounts to a conviction as required by the Constitution as to invalidate Tinubu's candidacy will be determined at the tribunal, number one. Number two, the conviction must have happened 10 years prior to the elections. I think the document that is being circulated is pertaining to proceedings that may be up to 30 years or thereabout. But again, I make no conclusions. At the end of it, it will be tested. Now, Shettima also, the issue of Shettima, he was. They said he had already been given a ticket to be the Borno State. Is it the Borno State, one of the senatorial districts in Borno State, and that so he was having been nominated as vice presidential candidate. He held a ticket for 2 constituencies at the same time, according to the LP petition. The presidential elections, or for the purpose of the presidential election, Nigeria as a whole being a constituency, well, I've also seen that grounds. But let me tell you something about election petition. I have done election petitions severally. I can tell you that because of how the law is, and because of several decisions of the court, including the Supreme Court, especially the Supreme Court, it is of Nigeria. It is easier for a camel to pass through the eye of a needle than for a petitioner in an election petition in Nigeria to succeed in his petition. It's
but we've
very
seen
difficult.
I mean, we've seen elections overturned. That's why we have some off-cycle and staggered elections. So, I mean, these things do happen, but not on the presidential level.
Yes. So this would be the first. I'll remind you of 2011. What happened in 2011? Buhari had filed his petition, and he was represented by a very competent lawyer, very experienced, Mike Ahamba, and had an elaborate grounds to show that he had been deprived of his mandate. But do you know why that petition never saw the light of the day? That petition never went to trial. It was dismissed in limine. You know why? Because of 15 naira filing fee. 15 naira filing fee. Wow. The entire mandate, claim to the mandate of the presidency was thrown out of the window. Election petitions, they said he didn't pay that 15 naira for filing, not even filing fee for the petition itself, but for filing of a pre-trial information sheet, which comes midway the petition. And so the entire thing went. It's a highly, unfortunately, our courts have used the word sui generis, whatever that means, to reduce election petition to a highly technical fray. And so for a mandate that concerns, so what our judges unfortunately have not been able to do has been to draw the line between, to connect the dots between the decisions they give and the state of the nation.
Okay, so I would like, Fidel, I would like to bring in Festus Oguns into the conversation at this point in time. Now, Festus, looking at the election tribunal, election petition tribunal, is there a time frame for them to make a decision? Because May 29th will be, is always.
Okay, I think we still have Barrister Albert while we wait for Barrister Oguns.
I'll just direct that question back to you, Fidel Albert. Now, yes, we have.
I think at the court of first. Yes.
Looking at the
yes, I'm hearing.
Inauguration date is May 29th. Is there a time frame for the election petition tribunal to pass judgment and make a decision? And also the fact that you have multiple people, multiple parties, I beg your pardon, also challenging this resource. Does it make their case any better? Will they argue individually or collectively?
So it can't be collectively. It's going to be individual. Every case will be taken on its own merit. So, but although in the same court. So May 29th does not affect the proceedings. Someone will be sworn in, but the proceedings will continue. They have 180 days, I think, to conclude at the court of first instance. If there is an appeal, then they would have 60 days to conclude. So 6 months and then 2 months for appeal. But it doesn't mean that swearing in will await the decision. Someone will be sworn in and the proceedings will continue. If the court says that you were not validly elected, then you would have to, there would have to be a re-election. That's what the court orders. Or if the court also orders that someone else should be the validly sworn in president, then it means you will step aside like it happened in Bayelsa. Don't forget that in Bayelsa, it was, I think the day before swearing in, that the court gave a decision removing they would be governor and bring in. So the preparations that were being put together for his swearing in was actually used for another person. So so that's how it works. The proceedings will continue. Someone will be sworn in. If the court decides otherwise, the person steps aside, and the next person comes in.
Okay. All right, now thank you so much, Barrister Albert. I'd like to bring Barrister Oguns into all of this. And one of the major things that the petitioners are hinging on is the fact that there's been non-compliance of the Electoral Act. But first of all, there's also been the issue of the president-elect, that is Bola Tinubu, actually securing the majority of lawful votes cast, and there has been discrepancies of having the FCT to thirds or the popular votes cast in the election. So can you tell us what of the requirements, the major requirements needed for the authentication of a president-elect in the country?
Well, thank you very much. I think a good way to start is to mention that when elections are conducted, or after the conduct of an election, the candidate or a political party can approach the tribunal to challenge the outcome of an election on 3 grounds: on whether the person who was elected or deemed elected or declared winner was qualified to have contested the election. It can also be challenged on the ground that the election was marred by corrupt practices and non-compliance with the Electoral Act. And finally, it can also be challenged on the ground that the person who was returned or declared as the winner is not or was not elected by the majority of the lawful vote cast. Now, in Mr. Peter Obi's and the Labour Party's petition, they have challenged the election of Mr. Bola Tinubu on the ground that, first, he is not qualified to have contested the election. They relied on the fact that his presidential candidate has a case of double nomination, or he allowed himself to be nominated twice as a senator and as a vice president. Under the Electoral Act, that is a ground for disqualifying a candidate. But however, our own concern is that we are deeply concerned whether challenging the issue of double nomination at the tribunal is not statute barred. Some have argued that it is a pre-election matter that should have been brought before the conduct of the election. But that's a different case entirely. On the other hand, the issue of conviction or forfeiture in the United States has also come up. Like my respected senior has mentioned, this is they are also concerned as to whether the issue of conviction can be brought forward when the very conviction talked about happened sometime in 1993, about 30 years ago, whereas the Constitution stipulates 10 years preceding the time of the election. That means that the person whom one is challenging its qualification should have been convicted for offenses relating to dishonesty within the last 10 years before the election was conducted. Again, this will be decided by the tribunal. But the interesting part of the petition, in my respectful opinion, is the issues relating to the fact that INEC did not comply by the extant laws, by the Electoral Act and its regulation in the conduct of election. Again, Mr. Peter Obi has also raised the issue as to whether Mr. Bola Tinubu was duly elected by the majority of the lawful vote cast. The Labour Party's presidential candidate says that there were overvoting in Benue and Rivers State. These are serious allegations that needs to be supported by credible evidence at the tribunal. So I do not think that the petition is one that should be dismissed as a child's play. It is one that if the evidences are adduced in support of the claims therein, I think it would be an interesting one that will patiently wait for it to unfold. And on the last point, the issue relating to whether it is a mandatory requirement for a presidential candidate to have won about 25% in Abuja, the Federal Capital Territory, to be declared as a president-elect. In my, there has been controversies in that respect before now, where lawyers have taken sides as to whether that should be a ground not to return a candidate or otherwise. Some are of the view, some people like me are of the firm view that wherein, assuming you have won the 36 states of the Federation, you've won handsomely over 25% in all of the states, and you have not won Federal Capital Territory, or you have not scored 25% in the Federal Capital Territory alone. Should that be a good ground to disqualify you or not to declare you as the winner of the election? These are issues that we expect the tribunal to make landmark pronouncements on. But tall and short, I think it is only painful and quite unfortunate that in this country, we are now leaving the duty of conducting elections to our courts. By the grace of God, I was at the election petition tribunal sometime last week, I think on Monday and Tuesday, for some matters, and you will see how the courtroom or the tribunal was filled up to the brim. That is to tell you that when you see irregularities here and there, when you see issues of non-compliance here and there, definitely the process leaves a lot to be desired. And that is, I think, the take-home in all of this. For how long shall we continue to leave the duty of conducting elections to our courts?
All right, thank you so much.
The issues that concern me
and I guess that's why we're here in the first place.
Yes.
If INEC has done a spectacular job, if all the stakeholders have done their job, no one will question the legitimacy of the process. I'd like to say a big thank you to you, Barrister Festus, Oguns, human rights lawyer, and also Barrister Fidel Albert for joining us in the conversation. I wish we had more time to thrash this out, but I'm sure in the nearest future we'll have you back on the conversation. Thank you.
Thank you for having me.
Thank you very much. Yes. Yeah.